Hello, and welcome to the Ministry of Government Relations webinar on processing subdivision referrals. This webinar is intended to assist municipal administrators and councils as they review subdivision applications received from the Community Planning Branch. In this webinar, we will examine the legislation that regulates subdivisions, the subdivision application review process, how municipalities can participate in the subdivision review process, and municipal responsibilities following subdivision approval. This webinar is based on the content of the Municipalities and the Subdivision Process Guide, available on Saskatchewan.ca. The Planning and Development Act 2007 establishes the framework for municipal planning in Saskatchewan. The Act also defines what a subdivision is and the requirements for subdivision approval. There are three regulations created under the authority of the Act: the Dedicated Lands Regulations, the Subdivision Regulations, and the Statements of Provincial Interest Regulations. The Dedicated Lands Regulations govern how publicly dedicated lands, such as municipal reserves and environmental reserves, may be used, as well as how money from a dedicated lands account may be collected and spent. The Subdivision Regulations contain the review criteria for processing applications to subdivide new parcels of land. The Statements of Provincial Interest Regulations contain 16 key policy areas where the province and municipalities have a shared interest. Any subdivision must conform to these statements. Under the Act, a subdivision is a division of land that will result in the creation of a surface parcel or parcels, or the rearrangement of the boundaries or limits of a surface parcel. A subdividing instrument is an interest in land less than title based on an agreement, easement, lease or mortgage, or other document or group of documents. Unless exempt under the Act, every subdivision and subdividing instrument requires approval from the relevant approving authority. Examples of subdivisions include the creation of a new parcel for a farm site from a quarter section, or the creation of parcels and a road along a lake for the development of cabins, moving an existing property line between neighboring parcels, and the removal of a parcel tie that links two or more parcels together. Subdividing instruments that require approval include a lease for only part of a parcel that, combined with renewal terms, exceeds 10 years, and certain easements. Under the Act, municipalities may adopt municipal planning bylaws. The term municipal planning bylaws refers to district plans, official community plans, and zoning bylaws. A district plan is a statutory plan adopted by two or more municipalities that form a planning district. The district plan guides development in those areas agreed to by those municipalities. An official community plan is a statutory plan which contains the long-term vision and goals for a specific community in the form of policy statements. The zoning bylaw is the primary tool for implementing the district plan and official community plan. It does so by organizing land uses and development to meet broader community objectives. A subdivision application must conform to the requirements established in these municipal planning bylaws. Let's examine zoning bylaws in more detail. The purpose of a zoning bylaw is to organize the use of land for the health, safety, and general welfare of the community as a whole. A zoning bylaw organizes development by dividing a municipality into zones using the map attached to the bylaw. In each zoning district, there is a list of permitted land uses that can be established in that zone. There may also be a list of discretionary land uses that may be established in those areas with council approval. Any land use not listed as permitted or discretionary is considered prohibited in that zone. A zoning bylaw will also establish development standards such as minimum lot sizes and frontage, and setbacks of buildings from property lines. The subdivision regulations also establishes minimum parcel dimensions, which apply to subdivisions in municipalities that have not adopted a zoning bylaw. The Act provides the authority to the Minister of Government Relations to declare a council, district planning authority, or regional planning authority an approving authority. These municipalities are responsible for subdivision within their jurisdiction and may adopt a subdivision bylaw that replaces the subdivision regulations. There are 10 municipalities in Saskatchewan that have been granted approving authority status. For all other municipalities, the Community Planning Branch of the Ministry of Government Relations is the approving authority for subdivision applications. A subdivision application that is reviewed by the Community Planning Branch typically follows the following steps. First, a property owner will need to approach a surveyor to have a plan of proposed subdivision drafted, showing the proposed subdivision including setbacks of buildings to property lines, existing and proposed servicing within the subdivision, roads within or connected to the subdivision, elevation points, and other items defined in the regulations. Once a plan of proposed subdivision has been drafted, It and all other supporting documents will need to be submitted to the community planning branch. The application is then assigned to a planning consultant who will work with the applicant and referral agencies through the subdivision review process. The planning consultant will conduct an initial review to determine who the application should be referred to. This will include municipalities affected by the subdivision, crown corporations, relevant provincial ministries, and external agencies. From the date of circulation, referral agencies are given 40 days to provide comment on the application. Any referral agency can request that the approving authority extend this 40-day referral period. A rationale for this extension must be provided, and allowing the extension is at the discretion of the approving authority. Once all comments have been provided and the application is deemed complete, a decision will be made on the application. The planning consultant map shows which planning consultant is responsible for reviewing subdivision applications within each respective municipality. Up-to-date copies of the map can be found on saskatchewan.ca. Municipalities can actively participate in the subdivision process in several ways and can be involved at various points in the application process. In some cases, a subdivision applicant may reach out to a municipality before submitting a subdivision application to the community planning branch for review. As early in the process as possible, the municipal administrator should take the opportunity to initiate a conversation with the developer of a proposed subdivision. The administrator often represents the municipality, provides information and advice, and acts as a liaison with council. Relationships are important, and a good relationship will help clarify the needs, interests, and specific zoning requirements of the municipality for the developer. This relationship will help the developer to prepare the plan of subdivision. An administrator may take a proposed subdivision to council for consideration before a formal subdivision application is submitted to the community planning branch for review. This may allow a municipality to identify issues early on in the process and for council to issue a recommendation on the subdivision before a formal application is submitted to the community planning branch. A subdivision application will be referred to a municipality from the community planning branch through a municipal referral letter. This letter will request council's comments on the proposed subdivision, including any land uses or site conditions that may impact the proposed subdivision, any facilities that may be affected by the proposed development, and any requirements council may have of the applicant. This referral will also request a resolution from council recommending approval or refusal of the application, and any reasons for refusal if that is recommended. Comments are typically generated by preparing a report to council on the application. Such a report may address several items, including if the municipality's planning bylaws need to be amended to accommodate the subdivision, and if those amendments are in the best interests of the municipality, how the subdivision will be serviced and whether a servicing agreement is required, if municipal reserve land is required and how this requirement may be met, and the suitability of the site for subdivision. Common items that may be considered by council are addressed in the following slides. If a subdivision does not meet a requirement under the zoning bylaw, the subdivision applicant may apply to amend the zoning bylaw. As an example, if a developer has applied to subdivide 3 residential lots from a quarter section, the proposal may contravene a municipality zoning bylaw if there is a limit on the number of residential subdivisions from a quarter section. In this case, the developer may apply to amend the zoning bylaw to rezone those properties to a zoning district that would allow for the subdivision of 3 residential parcels. An amendment to the zoning bylaw may also require a change to the municipality's official community plan and/or district plan. Continuing with the previous example, if the area being subdivided was in the agricultural district and is being rezoned to the country residential district, this may also require that the area be redesignated to country residential in the official community plan or district plan. If a municipality has adopted an official community plan, they may also adopt a concept plan as a part of the official community plan. A concept plan is commonly used to guide the development of a large subdivision over phases. The concept plan allows for the layout of the entire subdivision to be defined, including the road design, location of services, drainage needs, and the density or type of development. It is also useful in coordinating the development of lands owned by a variety of parties, or to outline the development of future neighborhoods. There may be other bylaws that need to be considered by council as a part of the review of a subdivision. One common example is a road closure bylaw, which would be required if a portion of unused road is being closed and consolidated with neighboring properties. While road closure bylaws are reviewed and approved by the Ministry of Highways, the Community Planning Branch will require a copy of the approved bylaw if it is required as a part of the subdivision. A common agreement that may be entered into by a municipality is a land sale or exchange agreement. These may be required if the municipality is exchanging municipally owned land for privately owned land, or if the municipality is selling land for private development. A servicing agreement is a legal contract that a municipal council may require of a subdivision applicant. With this agreement, council accepts responsibility for maintaining services in a new subdivision in exchange for the developer installing the services needed for the subdivision. A servicing agreement can also include fees for capital costs for providing, altering, expanding, or upgrading services that support the subdivision, such as wastewater, water, drainage, road, and parks and recreation facilities. Using the previous residential subdivision as an example, the municipality has identified that the road providing access to the proposed residential lots is only a seasonal road and would need to be upgraded to an all-season road. The capital costs related to upgrading the road could be charged to the developer as a fee under the servicing agreement. The agreement may also include required drainage upgrades, such as the installation of culverts to direct stormwater runoff. Under the Act, a servicing agreement can only be required at the time of subdivision. Due to this, it's important that a municipality identify whether a servicing agreement is required for the development of a subdivision. If council requires a servicing agreement, municipal administration will need to provide the Community Planning Branch with a copy of the agreement once it is executed by both parties. Dedicated lands are used for public amenity and environmental protection. At the time of subdivision, an applicant might be required to provide various types of dedicated lands. This could include land as environmental reserve if there is land that is environmentally sensitive or naturally hazardous, or land as municipal reserve for parks and community buildings. Unless a subdivision is exempt from dedicated municipal reserve land under the Act, a portion of the land to be subdivided must be designated as municipal reserve land. These lands are intended to function as public recreational spaces and may include public parks and community buildings. Municipal reserve dedication can be met through the dedication of land, the developer providing cash in lieu of that land based on market value, or deferring the dedication to a future subdivision. How dedication is met is at the discretion of the approving authority. As a municipality has the best understanding of their community's needs, a decision on the method of dedication, as well as the size and location of the dedicated lands, will take into consideration comments from the municipality. As municipal administration and council members live in the community, this referral process provides an opportunity for municipalities to provide information the approving authority may not be aware of. One example would be a proposed subdivision being located in an area subject to seasonal flooding. These considerations may also deal with land use conflicts, such as a proposed residential subdivision being located near a site used for fertilizer storage. In some cases, municipal facilities could be impacted by a subdivision. It's important that a municipality identify facilities in proximity to a proposed subdivision that could be impacted, such as landfills, transfer stations, lagoons, or water treatment plants. Their proximity to the subdivision could result in the redesign of the subdivision so there is a sufficient separation distance between land uses. Once council reviews a subdivision, a resolution from council will need to be provided to the Community Planning Branch. This resolution will need to include a recommendation from council to either approve or refuse the application. If council recommends refusal, the resolution should also include the reasons for why the application should be refused. The resolution will also address any other comments from the municipality, including site-specific considerations, what is required of the applicant, and any other items that may require approval. The Community Planning Branch will need to be informed as these items are completed, as in many cases, a decision on the subdivision application cannot be issued until these items are dealt with. Following subdivision approval, the municipality should monitor the progress of the project. This will ensure the project meets the standards of approval and any technical requirements set out in the geotechnical or engineering plan or servicing agreement. When a developer is responsible for installing utilities as a part of a servicing agreement, the agreement will typically identify standards that the utilities need to be installed to. It's the responsibility of the municipality to inspect these services at times identified in the agreement to ensure they are installed to the correct specifications. Once the subdivision is registered and the new parcels are created, development permits may need to be applied for. Any development permit may also need to comply with standards identified during the subdivision, such as geotechnical reports. This concludes the webinar on processing subdivision referrals. If you have any questions about the content of this webinar, please contact the Community Planning Branch using the information shown on screen. Additional resources such as the Amending Planning Bylaws Guide and Dedicated Lands Handbook may be found on Saskatchewan.ca. Thanks for watching.